Yes. Make a first call.
We have mentioned.
My Lord, I am the President of the Sankasi Imam of Ndam, that I have received a letter, and when I send a letter to your court office, then the Judge Registrar of this Honorable Court asked.
So you said?
The President of the Sankasi Imam of Ndam.
Yes, sir, I see. Yes, what is your grievance?
That letter petition, my Lord.
What is the grievance?
Huh?
What is the grievance?
The grievances is about one of our land, that our religious land in Mount Sandam village, that there is a place of worship by the Nyamkasi and Hindu communities. There is a shivling there. Every year our Nyamkasi and the Hindu communities during the month of Sawan and Navaratri, they perform the puja there.
No, but then the civil court should decide that. Why public interest litigation?
Because I write a letter petition because our organization don't have any money to fight a case. That's why we write grievances.
It doesn't have money to legal aid.
You can avail of legal aid. We can provide for legal aid.
Yeah. Because the register also is, the land also is, Madam is already registered. And then,
You have written a letter.
yes, I have already written. All detailed information already written in the petition.
All that let it appear as to be mentioned in the list
Yeah.
tomorrow.
Yeah.
And we will consider it in detail. Let it appear as to be mentioned, this matter.
Okay. Thank you.
Item number 1.
You are ready to proceed with the matter?
Lordship, yes.
Yes, you. All right, pass over. Next. All item number 2.
Item number 2.
Please, Your Lordship, the leading counsel is unable to appear, Your Lordship. As such, I'm praying for 3 weeks' time, Your Lordship.
It's a service matter.
Your appeal.
Madam.
The order is in their favor.
What is in their favor?
What is the order?
Your Lordship, the order, it says that to allow the petitioner to participate in the recruitment process. It is a treatment of the LASIK surgery, Your Lordship. The same treatment was given to the doctor, but it was not given to the staff nurse. But the single judge allowed in my favor, Lordship.
This is pertaining to recruitment in Assam Rifles, Madam, to the post of staff nurse. The respondent was suffering from eye problem, right? And she is undergoing LASIK surgery.
Learned counsel for the respondent. Once again, praise for adjournment. Dr. N. Moziko, Deputy Solicitor General of India, appearing for the appellants, does not oppose it. By consent of learned counsel for the parties, this appeal is adjourned till when?
3 weeks, Your Lordship.
Give the date.
29th May, Your Lordship.
29 May?
Yes, or last week of May, Your Lordship.
No.
14th of May, 14th to 15th of May.
14 May. On the condition that the respondent shall not take any steps in contempt or any other step to enforce the order under appeal, comma, in the meantime.
Nip,
Number 3.
May it please your Lordship.
Yes.
Lordship, with the consent from the other side, your Lordship, I pray for some accommodation in this matter, your Lordship, on behalf of the senior leading counsel, Mr. D. Das, your Lordship, as he's suffering from back injury, your Lordship.
Item 3.
Item 3, your
You are
Lordship.
for the appellant.
Yes, your Lordship. Lordship, I'm praying for 4 weeks' time, your Lordship.
Not 4 weeks' time. This is the problem here. Every matter is adjourned. But there are sufficient number of matters here. 15th May. By learned counsel for the appellant. Place for adjournment. Learned Advocate General. Appearing for the respondents does not oppose the same. By consent of learned counsel for the parties. This appeal is adjourned till 15th May.
I have Lordship.
Item
These
number
appeals. No, no.
Only one.
All the past 4 items.
case. In this case. Second call, item number 1.
Item number 4 will be called out at 12:30. Yes, what is this appeal about?
May it please your Lordship. Lordship, this is a appeal against the impugned judgment and decree passed by the Learned Commercial Court, your Lordship. The fact of the case, your Lordship, is that the respondent herein, your Lordship, he was a contractor. He was allotted a contract for the construction of officer and staff quarter at Camp Bikri in West Carville district, your Lordship. If Lordship kindly come to
Let us come to the impugned judgment, 201.
Lordship. Your Lordship, please. Lordship, we start from page 203, your Lordship. The fact of the case start at page 04, your Lordship.
This 985 has been paid.
Lordship, yes. Oh, no, Your Lordship. Look at, not yet, Your Lordship. The tender value, the tender is of, tender value is 70,82,800, Your Lordship. Out of that, Your Lordship, government has paid 68,97,704, Your Lordship, and the remaining is 9,85,096 only.
That has been paid.
No, that is, then what happened, Your Lordship? He filed a suit. He filed a suit and he claimed the relief, Your Lordship, up to 1,07,03,265, Your Lordship. The suit, Your Lordship, in my humble and respectful submission, Your Lordship, is barred by the law of limitation, Your Lordship. It is the admitted fact, Your Lordship, as pleaded by the plaintiff respondent, Your Lordship, that the cause of action arose in 2008, Your Lordship. If Your Lordship kindly come to page 9, Your Lordship, of the memo of appeal. He completed the building, Your Lordship, in 2008, Your Lordship. In the same year, Your Lordship, he demanded the payment of the bill, Your Lordship. And he waited, Your Lordship, for 3 years. And in 2011, Your Lordship, he issued a notice and through a council, Your Lordship. Then in 2013 also, he issued a letter to the authority. In 2012 also, in 2014, and at last, Your Lordship, in 2015, he issued a legal notice under Section 80 of the CPC, Your Lordship. And to that, Your Lordship, there was a response to Section 80, Your Lordship. Lordship, kindly come to page 192. This is the respond to the legal to the notice under Section 80, Your Lordship. Then in the year 2016, Your Lordship, he filed a suit, Your Lordship.
The contract is of which year?
Lordship, this is the contract of 2008, Your Lordship. The respondent plaintiff, Your Lordship, he led the evidence, and during the course of cross-examination, he admitted, Your Lordship, that the building was completed in 2008, Your Lordship. He submitted the bill in the year 2008 itself, Your Lordship. There was an issue frame on that, Your Lordship. If Lordship can come to page 218, that is the issue number 2.
It's mainly on the point of limitation that you want to argue this appeal.
Lordship.
It's mainly on the point of limitation.
Limitation, Your Lordship, yes.
But irrespective of limitation,
Lordship.
you're the government.
Lordship.
If 985 is the admitted amount,
Lordship, he filed a suit, Your Lordship. He filed a suit claiming the relief of 1.7 lakhs, Your Lordship, because the total value of the tender is 70 lakhs 82.
yes, that is left to be calculated by the department, by the decree.
Lordship, yes.
By the judgment, the learned judge says that the differential amount will be calculated. We are not looking at that. We are looking at the admitted amount.
The remaining is 9,85,000 only, Your Lordship.
There is a matter fixed now. We will hear you again tomorrow.
Lordship.
Please take down. Learned counsel for the appellant opens his argument but does not conclude the same. Let this appeal retain its position in the list.
Lordship, if I may pray, if on 24th, Your Lordship. 24th, Your Lordship.
24th.
Highly obliged. No, 24th, day after tomorrow.
Please finish it on 24th. Don't watch your don't
Certainly, I'll complete it, Your Lordship. Highly obliged.
What's the fixed matter?
Item number 4 on file.
Yes, Mr.
The Lordships will recollect that, my Lord, the challenge is to two notifications. One is, my Lord, which amends the Meghalaya excise rules, and the other which amends the Meghalaya bonded warehouse rules.
Yes.
My Lord, we had, my Lord, challenged it saying that this, my Lord, creates, number one, a monopoly in the hands of a single entity, which, my Lord, in this case was the central bonded warehouse. Second point of challenge was that, my Lord, this is ultra vires the statute itself, since section 19, my Lord, prohibits the creation of such a monopoly. Third point was, it was, my Lord, completely arbitrary, because, my Lord, it created, my Lord, an inequality amongst persons similarly situated, and, my Lord, disturbed the level playing field. Well, I will not, my Lord, labor over what I have already submitted before, just, my Lord, to refresh your Lordship's memory, very briefly. My Lord, previously, my Lord, the route to market was, there is the distiller or, my Lord, bottler. My Lord, he, my Lord, ultimately sells to bonded warehouses. There are about 45 bonded warehouses in the state. My Lord, the bonded warehouses in turn, my Lord, sell to the retailers, who in turn sell to the consumers. So, my Lord, the bonded warehouses, all 45 of them, were individually placing orders on the different bottlers, distillers, etc., who were, my Lord, supplying to them. The bonded warehouses were, my Lord, retaining a commission of about 8%. And thereafter, my Lord, the goods were being, my Lord, supplied to the retailers, and then from then onwards to the consumers. Now, my Lord, what happens by reason of these notifications is that there is now, my Lord, imposition of, my Lord, an entity called a central bonded warehouse, a solitary entity. Now, my Lord, the central bonded warehouse is the only entity which has the authority to place orders on the distillers and bottlers, receive supplies from them, and then give these, my Lord, goods to the different bonded warehouses, who in turn, my Lord, give it to the customers. Now, my Lord, they are not performing any new service. They are not performing a different service. They are not performing any extra service. It is just that, my Lord, now, whatever the 45 bonded warehouses were doing is being done by the central bonded warehouse. One entity replaces 45 but does not really replace them. My Lord, adds another layer. Now, my Lord, here, my Lord, if your Lordship now considers it from the context of, my Lord, how, my Lord, the pricing of the product is thereby affected. Now, my Lord, the bottler has a price. Let us say the price is 100. My Lord, it reaches ultimately, my Lord, the bonded warehouses. The bonded warehouses, my Lord, out of that 100 will retain a commission of, let us say, 8 rupees. Because, my Lord, this has to come within the X bond price that is decided by the state. So, my Lord, 100 minus 8 is what, my Lord, is paid to the bottler or distiller. So, the bottler or distiller gets paid about 92 rupees. Now, my Lord, what will happen is, with the imposition of the CBW, Central Bonded Warehouse, they, my Lord, will keep a commission. So, my Lord, now, out of that 100 rupees, there can be two circumstances, two consequences. Out of this 100 rupees, my Lord, CBW retains its commission, my Lord, which it had indicated in one of its communications, would be 25%, of course, taking into account the bonded warehouse commission. So, my Lord, now the price will have to accommodate the CBW commission, the bonded warehouse commission, before it reaches, my Lord, the retailer. So, either this, my Lord, impact of the additional commission will have to be borne by the bottler or distiller, or ultimately it will have to be borne by the consumer. Now, in either cases, one is, my Lord, my price is affected, my route to market is affected, and secondly, my Lord, otherwise, my Lord, if it ultimately finds reflection in the pricing of the goods when it reaches the consumer, well, in that case, my Lord, ultimately the demand for the goods will also be affected. My Lord, that is, my Lord, the principal challenge, but my Lord, the legal challenge, my Lord, was somewhat different. My Lord, today, even if something, my Lord, ultimately impacts my pride, but answers the question of legality, then, my Lord, I may not have a say. But in this case, what was happening is, my Lord, here, the creation of this, my Lord, single entity CBW, my Lord, was creation of a monopoly, which violated, my Lord, Article 19(1)(g) with its exception under Article 19(6). Because Article 19(6) very clearly provides that the state may impose reasonable restrictions but cannot create a monopoly unless the state is creating the monopoly for itself. So, my lord, that was the first round of challenge. The second challenge was, my lord, that this is statutory ultra-virus. My lord, that your lordships will kindly have a look at, my lord, just one provision of the statute which I had earlier shown your lordships, but my lord, some time has passed. I just want to draw your lordship's attention very briefly to that provision. Please see, my lord, section 19 of the Excise Act once.
Excise Act.
May I request your lordships to kindly have a look at section 19. Well, the language of the statute is very important. The state government may grant to any person on such condition and for such period as it may think fit. Now, well, here, kindly see the exclusive privilege of manufacturing or of supplying to licensed vendors or of manufacturers supplying to licensed vendors. Now, my lord, here this is very important. Exclusive privilege in respect of what? Country liquor or intoxicating drug. My lord, Indian made foreign liquor, which is, my lord, the subject matter for consideration here, which is, my lord, what the distillers and, my lord, the bottlers manufacture, does not fall within either country liquor or intoxicating drug. And the second limitation here is, my lord, it is, my lord, ultimately to be confined for a specified period within any specified local area. So ultimately it is to, my lord, confine itself to, my lord, any specified local area which might ultimately, my lord, throw up the cause for imposing such restriction. Now, my lord, here the imposition is across the state of Meghalaya. Intoxicating drug is defined in the statute. It is definitely not an intoxicating drug. Liquor includes both IMFL and country liquor. But, my lord, my learned friends have not contended that, my lord, what is within the purview of consideration for the court presently is, my lord, Indian made foreign liquor. He says it's country liquor, and country liquor is the only thing to which the exception or the, my lord, exclusive privilege can apply. Now, my lord, in this respect, I had, my lord, cited before lordship, my lord, judgments to show that ultimately, my lord, so far as the delegated or subordinate legislation is concerned, it must answer to the plenary, my lord, statute. It cannot overwhelm, my lord, the plenary provisions of a statute and create substantive rights. The delegated legislation is always for the purpose of implementing the provisions of the statute and not for creating fresh rights or fresh, my lord, obligations in themselves. Now, my lord, in that regard, I had already relied on judgments before lordship. I do not want to trouble your lordships with that anymore. The second aspect which I had highlighted before lordship is the doctrine of expressio unius est, exclusio ulterius. But this clearly says the expression of one is the exclusion of other. So, if today, the statute clearly says that if this exclusive privilege is to be confined only to, intoxicating drug and country liquor, then, it excludes within the purview of, the rigors of this section 2, Indian-made foreign liquor. For that also I have, cited decisions which I will not trouble your lordships again. So, I had covered in extenso the, argument with regard to section 19 of the statute, how, the question of exclusive privilege has been statutorily limited only to intoxicating drugs and country liquor. And, I have relied on decisions to make good my submissions in that regard. Now, the second aspect of the matter with which your lordships are now concerned is the aspect of, monopoly and with the aspect of arbitrariness. Now, if your lordships will kindly, in this regard, once consider as to, what is the case with which I had come up before this court. Well, initially, when this writ petition was moved, I was asked to file a supplementary affidavit to explain as to what is the prejudice that I will suffer in case these, my lord, notifications are given effect to, that are amending, my lord, the bonded warehouse rules and the excise rules. But that supplementary affidavit was ultimately filed by me, my lord, on 14th of September 2021. Well, in that supplementary affidavit, I have highlighted, well, in great details, the exact prejudice to which I will be subjected to. Well, if your lordships will kindly have a look at that affidavit filed by the petitioner on 14 September 2021, well, I can just highlight very briefly what is, my lord, the situation that will befall the petitioners in case this is, my lord, ultimately given effect to. So I need to briefly show you lordships. I need to briefly show you lordships, my lord, this to, my lord, put forward my argument on Article 14 and Article 19 to show as to how, my lord, this is violative of Article 14 and what, my lord, prejudice it causes me. Well, this affidavit was filed pursuant to, my lord, an order of court well, if your lordship will kindly see, my lord, paragraph 3 of the affidavit. Well, your lordship will find that we have ultimately, well, tried to jot it down in bullet points. Well, at first, your lordship will see CBW license creates a monopoly in private hands, and, well, thus the CBW licensee is at liberty to dictate the terms of business between the manufacturers and suppliers. So, my lord, first, my lord, point was creation of a monopoly, which naturally would give, my lord, the monopolistic entity the right to, my lord, ultimately dictate terms of business. Now, my lord, in this regard, it is very important to notice, my lord, one more thing. My lord, affidavits have been filed in this proceeding to show that, my lord, the persons who have now formed, my lord, the central bonded warehouse are persons which, my lord, also own bonded warehouses and manufacturing facilities of liquor in the state of Meghalaya. And so, my lord, ultimately this leads to a situation where both the upstream and downstream manufacture and supply is controlled by these entities. My lord, in this regard, my lord, your lordship may, my lord, just make a note of, my lord, 2 or 3 dates. My lord, here, my lord, the partnership firm which was granted the license as a central bonded warehouse, well, this was established on the 1st of September 2020. Just 3 dates, my lord. The CBW licensee, that is, my lord, the person who was favored with the license, and has now been, my lord, established as the central bonded warehouse for the state of Meghalaya, my lord, came into existence with the execution of a deed of partnership on the 1st of September 2020. Well, the amendment to the rules, which is under challenge presently, was thereafter, my lord, brought into effect on 15th October 2020. Well, kindly see how significant this is. This partnership firm, which is now the CBW, the respondent number 3 in the proceeding, is established on 1st September 2020. The amendment to the rules which are now under challenge were made on 15th of October 2020. Merely 6 days thereafter. And thereafter the tender, for granting the CBW license. Sorry to interrupt. 1st September and 15th October. 15th October. That's not 6 days. Sorry, my mistake. 1st September 2020, 15th October 2020. And the tender was thereafter floated. September is the creation of the partnership. The respondent number 3. And the amendment to the rules is on 15th October 2020. The tender is floated on 18th November 2020. Well, this clearly shows that, my lord, ultimately, the respondent number 3, which carried on no other business, was formed and established only for the purpose of, my lord, acquiring this license. So they knew, my lord, that this is what is going to happen. All predetermined. And, my lord, we have ultimately demonstrated from affidavits that, my lord, the constituents of this partnership, the respondent number 3, are, my lord, one Ajay Kumar Agarwal, who is a director of, my lord, one DHY Organic Winery Private Limited, which is one of the, my lord, bottlers or distillers in the state of Meghalaya, and also the proprietor of one SK bonded warehouse. This is all an affidavit. My lord, the other, my lord, constituents of this, my lord, respondent number 3 are Neeraj and Pankaj Kapoor, who are directors of one MD Beverages Private Limited, another bottler distiller in the state of Meghalaya, and, my lord, one Janita Valam and one Sharad Valam, who are directors also of MDH Beverages Private Limited. So, my lord, they control, my lord, manufacturing facilities in the state and are now also, my lord, controlling the central bonded warehouse. My lord, what will happen is,
Now, your point is that the price is fixed. Out of that, a commission amount previously
Yes.
was you received. Now, because of this,
no, my lord, commission was received by the bonded warehouses.
yes, and
I am the distiller or the bottler. I have, my lord, a price. My lord, my price is, my lord, ultimately a price that is agreed to by the state. It is called the ex-bond price.
yes,
Now, my lord, let us say the ex-bond price is 100 rupees. I sell it to the bonded warehouse. Bonded warehouse keeps a commission of 8 rupees.
now because of this intervention of this central board, the commission is bound to be distributed or be distributed and increased.
And increase, which will affect my price or the price in the hands of the ultimate retailer. And, my lord, consequently, this will also impact
Your price first, as fixed by the government, then the ultimate retailer.
My lord, if today, my lord, ultimately they decide that very well the ex-bond price, my lord, will not be increased, this commission will be realized from the hands of the, my lord, consumers,
Then you are not affected.
then I am not affected, but the consumer price increases, which affects my demand.
Which decreases your demand.
Yes. And, my lord, not only that, today, my lord, there are several factors which we have highlighted in this affidavit that I was drawing your lordship's attention to. My lord, they can, my lord, ultimately impact, my lord, the storage of stocks. They can ultimately, my lord, impact, my lord, the credit facilities. They can influence, my lord, the demand in the market. And how, my lord, I have detailed all of that in this affidavit of 14th September. Now, my lord, very, very important is the fact that, my lord, when the matter was earlier argued, my lord, this court, my lord, came to a conclusion that yes, this, my lord, is arbitrary. And, my lord, an order was passed on the 20th of, my lord, June 2023, my lord, which is on record, which ultimately said that, my lord, yes, you must ultimately cure this defect. If your lordships will kindly have a look at that order once. Well, this, my lord, will ultimately cut through a lot of arguments. Please have a look at the order passed by this Honorable Court on the 20th of June 2023. And, well, how the state responded to that. Well, please see the order. Well, this ultimately clearly, my lord, captures, my lord, the prejudice aspect and, my lord, directs the state to, my lord, create a situation which will ultimately address these issues. Lord, may I just place this order for your lordship's consideration.
Date of the order, Mr.
20th June 2023. May I just place this order? Well, this will ultimately bring the whole matter to perspective because this received the consideration of this court before. Please see paragraph 2. The respondent number 3, well, this is CBW. The respondent number 3 has disclosed its partnership deed which reveals that there are 4 partners. According to the petitioners, the curious case of the third respondent, Central Bonded Warehouse, is that its partnership deed was executed sometime in September 2020 as if in anticipation of the new policy that was brought into place by the government in October 2020, and offers invited for a central bonded warehouse in the next month. The petitioners also point out that all the four partners of the third respondent central bonded warehouse also own distilleries, whether individually or with others, and further own and control several bonded warehouses. This by itself is against a fair process, since as owners of the distilleries, the partners are in the same position as the petitioners herein, and as owners of bonded warehouses, the partners become clients also of the central bonded warehouse. In the supplementary affidavit filed by the petitioners, it is indicated that though the government has fixed an ex-bond rate and the extent of commission to be passed on to the bonded warehouses, variable rates have been sought to be charged or threatened to be charged by the central bonded warehouse from different manufacturers. This, according to the petitioners, would be completely against there being a level playing field, since the higher rates charged from certain manufacturers and the lower rates charged from certain other manufacturers will have an impact on the quantum of supply and the products that ultimately reach the retailer's shelves. In addition, the petitioners claim that there are certain incentives which are selectively offered by the CBW or proposed to be offered that may further distort the price mechanism. At the same time, the petitioners point out that it is the considered stand of the state that it will not interfere in pricing, as that should be determined by market forces. The essence of the petitioners' contention is that if different sets of rules are applied to different suppliers of liquor to the CBW is in a monopolistic position to control the quantum of supplies obtained, and even though the CBW may ensure that it takes supplies from every manufacturer, yet the quantum of supplies would be dependent on the extent of income or profit that the CBW is able to glean from the relevant transactions. In the previous regime, when there were several bonded warehouses, the manufacturers, distillers, would enter into individual agreements with the bonded warehouses, and, though the terms thereof could be different, there would have been a level playing field and the agreements entered into at arm's length. The petitioners submit that just as if all the bonded warehouses formed a cartel and dictated terms to the manufacturers, some manufacturers may have benefited while others may have suffered. The CBW, in effect, is doing or intending to do the same. Now, this paragraph is most important, paragraph 6. This is a court's minor observation. Prima facie, an element of prejudice is made out justifying the institution of the present proceedings. At the end of the day, it is for the state to ensure that rules are in place that do not allow a solitary entity that has replaced a group of entities to indulge in monopolistic practices or dictate terms to the manufacturer or distillers, or to be in a position to decide which product and of what amount would land on the retailer's shelves. The state should know better and should bring in rules that will allow the demand at the level of the individual buyers to direct the supply of the product, rather than a state-appointed entity taking into account its profit-making exercise for deciding the same. So, the direction is for the court, for the state, to bring in rules, which would naturally mean the effacing of these rules, which are under challenge. Then, please see, since the CBW seeks time to ascertain whether it is charging differently from different manufacturers and distillers or is making certain rebates and concessions selectively available to some manufacturers, let the matter stand over for 3 weeks. Then the state will do well to address the several issues indicated herein to ensure that there is a level playing field and the manufacturers and distillers are not discriminated against. So, the court forms an opinion that there will be no level playing field if this system is introduced and tells the state to take remedial measures. Now, what does the question is, what does the state thereafter do? Please see the next order that is passed on 18 July 2023. Pursuant to the direction contained in the penultimate paragraph of the immediate previous order of June 20, 2023, it is submitted on behalf of the Central Bonded Warehouse that it is not necessarily charging differently from different manufacturers or distillers, but due to the cost of transportation being reduced, the benefit may be passed on by certain manufacturers or distillers to the CBW. So, it is ultimately admitting that it is charging differently from different entities. Implicit, please see the next paragraph. Implicit in such submission is that there is an element of possible differential treatment arising out of the differential margin for the CBW. All that the court is concerned about is that similarly placed persons should not be treated dissimilarly by the CBW, as that would result in monopolistic practices and certain other manufacturers and distillers losing out. The state says, well, kindly see this again, very important. The state says that the matter is being looked into. It is hoped that the state would regulate the relationship between the manufacturers and distillers on the one hand and the CBW on the other to ensure, as indicated in the previous order, a level playing field with no possibility of favoritism or discrimination. Then, this is the direction. Both the state and the central bonded warehouse should report on the matter within 4 weeks. So, here please see paragraph 2 of the order. This is very clear. Implicit in such submission is there is an element of possible differential treatment. And when the court directs reports to be filed by both the central bonded warehouse and the state. Now, thereafter, your lordship will see the state filed an affidavit on the 19th of September, and an order is passed by the court on 19th of September 2023. Please see the order of 19th September. Well, there was the previous order of 29th September, which I don't want to trouble your lordship with. It says, by the previous order of 29th August 2023, the court expressed apprehension that the state was not serious in allaying the misgivings of the petitioners or attend to the several anomalies that had been indicated in the matter pertaining to the setting up of a centralized warehouse for distribution and sale of foreign liquor in the state. The previous order required the modifications to the existing scheme or a revised scheme to be presented by way of affidavit when the matter appeared next. An affidavit has been filed today, though a copy thereof has been made over to the petitioners only this morning. The state refers to the second paragraph of the affidavit to demonstrate that some tweaking in the existing scheme has been made. However, the petitioners, without having the benefit of studying the affidavit in great detail, submit that it is merely a cosmetic change that is suggested in how central bonded warehouse functions. Now, thereafter, what the state did, in its affidavit, filed on 22nd February 2024.
Subject to what you and Mr. Banerjee think, there is no scope of all this. Either the whole of the notification goes, or a part of it goes, or a part of it remains and a part of it is
I am extremely
read down.
I am very grateful, my lord. All that I am trying to show.
This can't be converted into a writ and when the government will...
But in fact, what the state did, the state filed an affidavit and says, we are not thinking of introducing a second central bonded warehouse. So the court is already of the opinion that this is arbitrary. The court is already of the opinion that this needs to be amended. And the state responds by saying, we are now thinking of introducing a second central bonded warehouse, which incidentally, was challenged by the respondent number 3 in a separate writ petition before this honorable court. I am told that that was heard by the learned single judge. Hearing is concluded and the order reserved.
And as far as this Rule 19 or Section 19, Assam Act,
yes,
please come to it. What I was thinking, that because of the dangerous character of country liquor and intoxicating drugs and all that, the state takes upon itself the duty of nominating exclusive manufacturers for this and not leaving it into the hand of local brewers.
Absolutely. But then, the state takes into account the fact that
this is a rational differentiation or not.
Yes, it is. But it is confined to what? Country liquor and intoxicating drug. When today the statute confines the granting of exclusive privilege to country liquor, which does not include Indian-made foreign liquor or IMFL, and to intoxicating drug, the question is, can you, by reading the express words of this section, expand its operation to include IMFL? You cannot. And that is what clearly the judgments have said. It says that when there is a substantive legislation, you cannot by a delegated legislation or delegated piece of legislation ultimately do violence to the substantive legislation, because the delegated legislation only works out a modus for giving effect to the substantive provisions. And my lord, so far as that is concerned,
Then your submission based on this section 19 is, what is your submission?
well, my submission is, section 19 allows, my lord, the state to grant exclusive privilege only to intoxicating drugs and country liquor.
Yes.
Number one. Number two, it says that this must be confined to a specified local area. In this case, what they have done is granted this exclusive privilege in case of IMFL, which is contrary to the provisions of section 19, and made it applicable throughout the state of Meghalaya, not confined it to a specified local area. This, is ultra-vires the statute. This is ultra-vires the statute, and contrary to the manner in which such statutory provisions have to be read, applying the doctrine of exclusive unisex.
Supplying IFL.
Yes. So, this cannot
By the central board only.
Yes. Now, this creates the creation of a monopoly. Now, so far as that is concerned, what the judgments have held thus far is, of course, 19(1)(g) protects the right to or freedom to trade. 19(6) imposes reasonable restrictions. 19(6) says that reasonable restrictions can be imposed without, however, interfering with the general right of the general public to trade in goods, unless the goods are inherently dangerous or pernicious in character. Now, there the doctrine of res extra commercium has come in. The court has said that today, if the state feels it necessary to prohibit the trade in goods, because these are pernicious, then the state can do so. For example, there is prohibition in the state of Gujarat. There is prohibition in the state of Bihar. So, the state is within its authority to stop trade in goods which it considers pernicious. But for regions or states or locale, where there is no blanket ban on the trade that is ultimately imposed, then all that it can do is to regulate it. For example, you cannot sell beyond such and such hours. You cannot sell particular goods without description of how they will affect your health. For example, your lordships know that sale or advertisement of liquor is completely banned.
Yes.
There is no advertisement of liquor. Even today, your lordship will find that today they are advertising the mark of the brand by saying packaged drinking water and so on and so forth.
And soda, all these things.
Yes. So, these are the reasonable restrictions. But, when today, the ban, so you can ban it, you can, reasonably restrict, the route to market or, the manner in which the goods will be advertised, etc. Now, what you cannot do, the state can, create a monopoly for itself. The state can create a monopoly for itself, but the state cannot create a monopoly in the hands of another person. Please, have a look at just Article 19(6) once in this regard of the Constitution. Because this is the next limb of my submission. The first limb was 19(6).
19(1)(6). 81(g) is taken.
Now, 19(1)(g) permits everyone to carry on trade and business. Now, this is the imposition of reasonable restriction on the rights under Article 19(1)(g). Article 19(6). Nothing in subclause G. Nothing in subclause G of the said clause shall affect the operation of any existing law insofar as it imposes or prevents the state from making any law imposing in the interest of the general public reasonable restrictions on the exercise of the right conferred by the said subclause, and in particular nothing in the said subclause shall affect the operation of any existing law insofar as it relates to or prevents the state from making any law relating to. So, reasonable restriction can be imposed, but the state can make a law which ultimately, please see Roman 2. The carrying on by the state, so this is confined to the state. The carrying on by the state or by a corporation owned or controlled by the state of any trade, business, industry or service, whether to the exclusion, complete or partial, of citizens or otherwise. So, my lord, who can create this monopoly for itself? The state, and the state alone. That is, my lord, the language of my lord, section 19.6 Roman 2. Article 19.6 Roman 2. Now, my lord, this has been the subject matter of a lot of judicial discussions. My lord, the courts have held. My lord, of course, applying the doctrine of res extra commercium, you can, my lord, prohibit the trade in the goods themselves. But where you allow the trade, you cannot ultimately say, I shall create a monopoly in the hands of X or Y. Of course, the state can create a monopoly in itself. My lord, may I straight away take your lordship, my lord, to, my lord, the judgments in this regard, because, my lord, they will also, my lord, ultimately dwell on the, my lord, arbitrariness of the whole thing.
Yes.
The Article 14 is also...
19 and 14 will...
Yes, my lord, interplay between 19 and 14. Now, the first judgment I'd like to show you, lordships, in this regard is the decision of the Supreme Court in the case of Khoda Distilleries.
Mr. Shah, before that, just let us have a look at the notification again. The
Yes, my lord, yes. Well, if your lordship will kindly have a look at the notifications, my lord, your lordship will find the notification, my lord, the bonded, the Meghalaya excise rules notification at page 46 of the writ petition. First, the notification amending the excise rules and then the bonded warehouse rules.
Part 2. Part 1.
Writ petition at page 46. Now let's note the date, 15th October 2020, and then amendment of Rule 3. Amendment of Rule 3, it says, in principal rules, in Rule 3, Sub-Rule 2, for the word bonded warehouse, the word central bonded warehouse shall be substituted. However, my lord, bonded warehouses are not done away with. They are allowed to exist along with central bonded warehouse. Then amendment of Rule 4. In the principal rules in Rule 4, Clause Roman 4, for the word bonded warehouse, the word central bonded warehouse shall be substituted. So again, my lord, CBW is brought in without, my lord, doing away with the bonded warehouses. Then the important part is amendment of Rule 4A. In the principal rules, the existing Rule 4A, the following shall be substituted. Now, you kindly see this. Central bonded warehouse CBW shall apply import permit on liquor allowed for canteen licenses, etc., etc., etc. Then next sentence you will see. At the end of every quarter, that is the last day of March, June, September, December of every year, the central bonded warehouse shall pay to the state government the ad valorem on the remaining stock, if any applicable. So, well, ultimately, the central bonded warehouse is allowed to, my lord, perform the job that initially the bonded warehouses were, my lord, performing. Then, my lord, corresponding amendment was made to the bonded warehouse rules, which you'll actually find at page 43. That is also made on the same date, that's 15th of October 2020. Will you please see, my lord, the paragraph 2 of the notification, insertion of new clause Roman 2 small a in Rule 2. In the principal rules, in Rule 2, after the existing clause Roman 2, the following new clause shall be inserted, namely, central bonded warehouse means a licensed central warehouse where IMFL, beer, wine, BIO, etc., imported on prepayment of excise or ad valorem duty, import pass fee or transport fee, pass fee and literage fee are kept for removal, for eventual removal, to bonded warehouses. So, ultimately, CBW will import and then remove it to the bonded warehouses. Then 4A, then 44. Insertion of new Rule 44. Well, this is, my lord, what causes a lot of concern. License for central bonded warehouse shall be granted on the following conditions. A license to establish and work a central bonded warehouse in the designated area. Now, my lord, the designated area becomes the entire state of Meghalaya. On prior approval of government shall be issued by the commissioner. Please see, my lord, clause 4. My lord, this is, my lord, intended for a period of 10 years. The tenure of the license shall be for 10 years.
And that commission part?
Well, I shall come to that. Now, please have a look at, please have a look at the clauses 9 onwards. Clause 8 onwards.
So this we have all marked.
Yes. Now, my lord, so far as this is concerned, please see clause 12 with regard to the commission. The minimum profit margin eligible for bonded warehouses on their sale to retail IMFL off and on licenses shall be 8% for IMFL brands only except bottle. The central bonded warehouse or ex-bond warehouse of all imported goods shall be subject to the approval. And then, my lord, here, my lord, please see, so my lord, here at clause 12 it says 8% for bonded warehouses. What is the, my lord, commission that can be charged by the central bonded warehouse is not mentioned. So it can be anything. 8% bonded warehouse. My lord, central bonded warehouse not going to work for free. They will have to charge a commission, but what their commission will be is not, my lord, laid down. Then your lordship will see, my lord, 14, on commencement of the central bonded warehouse, the bonded warehouses shall lift all liquor from the central bonded warehouse against import permits issued by the commission and cease to import directly from the companies or bottling plants. Now, my lord, so far as this is concerned, now if your lordship will see, my lord, what they had wanted to do initially. But if your lordship will see, my lord, page 11 of the supplementary affidavit that had been filed on 14 September 2021. Well, since your lordships inquired about the margin, my lord, please see the supplementary affidavit of 14 September 2021 at page 11. This is the letter that had been written.
Thank you.
Just this one document, my lord, will, my lord, make it clear as to what is, my lord, the situation that is prevailing or what, my lord, can follow. Please see, my lord, the third paragraph of the letter. This is written by CBW to, my lord, one of the constituents of the petitioners. We suggest that the cost card should be finalized within 15th April 2021 and should include 25% margin, which includes 8% bond margin, freight, administrative and miscellaneous charges, and CBW margin. So, my lord, 17% is the CBW margin. Now, my lord, once, my lord, this became an issue in the writ petition, my lord, they have said that CBW is not charging any margin. It is because, my lord, there is a persisting challenge, prevailing challenge. But, my lord, what is important is that they have said that ex-bond price will accommodate, my lord, the margins to both bonded warehouses and CBW, which means that, my lord, if today the ex-bond price for the distiller or bottler is 100 rupees, and initially out of that only 8 rupees had to be paid to the bonded warehouses, now 25 rupees will have to be paid to the CBW and the bonded warehouse. Kindly see how it impacts, my lord, the price. Since your lordship's query was on the price. Because, my lord, there is no regulation of what is the margin that will be served by CBW. And where does it come out from? This margin, there is no, my lord, prescription for that. And, my lord, now the representation is that this will come out of the ex-bond rate. So it impacts my price immediately.
Where is the power of the government to fix this rate?
My lord, that is, my lord, where I showed you, lordship, my lord, the rules. If your lordship kindly sees the rules, the bonded warehouse rules once again, at page 43, clause 12. the minimum profit margin eligible for bonded warehouses on their sale to retail INFL off and on licensees shall be 8%. So, my lord, minimum that is to be paid to the bonded warehouses is 8%.
One of the various brands.
And, my lord, the rest is, my lord, for the CBW. Now, please see 13.
No, the bottle price.
Yes, next 13. The central bonded warehouse or ex-bond rates. My lord, this is determined by the government. The central bonded warehouse or the ex-bond rates of all imported goods shall be subject to the approval by the Commissioner of Excise. So, my lord, the ex-bond rate is, my lord, fixed by the Commissioner of Excise. It can be either called the ex-bond rate or the central bonded warehouse rate. Out of this, 8% minimum has to be paid to the bonded warehouses. And what is to be paid to the central bonded warehouse is, my lord, not, my lord, provided. And that allows the central bonded warehouse, upon getting the license, to say that we will charge 25%, out of which we shall pay 8% to the bonded warehouses, and the balance we shall keep for ourselves. And there you'll also find mention of freight costs, administrative costs, but these were always there. Freight cost was always there, administrative cost was always there. So, my lord, 17% was sought to be retained by the central bonded warehouse. And this apart, my lord, the other points which I have, my lord, flagged on the previous occasions, that, my lord, there is no, my lord, provisioning as to what the minimum stock is, how the minimum stocks will be lifted and provided. I have made detailed submissions on those. Now, my lord, the question therefore is, my lord, does this, my lord, notification provide for creation of a monopoly, A? And B, does this, my lord, ultimately, my lord, create uncanalized powers, or, my lord, fail to impose the requisite checks and balances to ensure that there is no misuse of the monopolistic, my lord, powers that have been vested on this entity? And for that I have given reasons, my lord, in my supplementary affidavit, and, my lord, I have also spelled out that since, my lord, there is no cap on the pricing, we are free to decide. Now, my lord, today, for example, your lordship has seen that pursuant to the first order, we say that no, we are not charging uniformly from all. We are charging differently, but that may be because some of them are foregoing the freight costs to us, which is an admission of the fact that they are charging different from different manufacturers. And when, my lord, you are controlling both upstream and downstream, it is bound to give rise to, my lord, a completely, well, anarchic situation.
Mr. Shah, we can continue tomorrow?
Yes,
It's fixed for 2 days.
fixed for 3 days, my lord. 3 days. But I need to just show your lordship the judgments and finish.
Mr. Shah continues his argument. List tomorrow for to hear further arguments.
Great.
এলে মুভি তোর সাথে কথা আছে